My highly respected and distinguished colleagues, with your permission, I want to come under Order 41. And with your permission, I would like to read it. It's on matters of urgent public importance.
Leader, did you say 41 or 42? All right, thank you. All right, thank you. You may proceed. Leader, use your mic.
By the indulgence of the Senate and the leave of the President of the Senate, a senator may make a personal explanation, although there be no question before the Senate. But no controversial matter may be brought forward, nor any debate arise upon the explanation. The terms of the proposed statement shall be submitted in detail to the President of the Senate when his leave to make it is sought. Mr. President, I think I approached you earlier today to secure that permission. With your permission, I read my matter of national importance.
Is it, Leader, you say personal explanation? Okay, go ahead, Leader.
I rise to first of all congratulate the 9th National Assembly for resisting the pressure from the executive arm of government to amend Section 8212 of the Electoral Act 2022. I also wish to congratulate the Supreme Court for the clarity, decisiveness, and unanimity of its verdict in upholding the separation of powers principle enshrined in our 1999 Constitution. Thirdly, I also wish to congratulate Nigerians for this major victory in our march toward true democratic governance anchored in the rule of law. In my view, Mr. President, the Supreme Court verdict should be celebrated for two reasons. The first one is that it restored and anchors the power of making laws in the National Assembly. The second one is that it established a principle that once a president assents to a bill, he or she cannot appropriate and reprobate. He or she cannot go to the courts to amend or reject the bill in part or in whole. This is a major principle that has emerged from this particular judgment. Secondly, Mr. President, I think we still, as a National Assembly, have a major outstanding matters that remain. That is, we have to, after the 2023 elections, study the entire implementation process of what had happened. So that in one thing we might need to revert to our earlier stance on direct primaries. Our recent nasty experience on the misuse of consensus and delegate system has vindicated our earlier position on the merit of direct primaries, provided that a verifiable membership register of political parties is kept simultaneously at the world level and with INEC, with all the necessary safeguards against corruption and data manipulation put in place. And thirdly, finally, we have a responsibility in this 9th Assembly that as the political process towards 2023 unfolds, the National Assembly needs to be observant of the loopholes and weaknesses of the 2022 Electoral Act, so that a comprehensive assessment is undertaken to provide adequate grounds for making amendments to the Act before the end of the term of office of the 9th National Assembly. This is my personal explanation. Thank you for giving me an opportunity to raise this, Mr. President.
Abdullah here, the former leader. Because this is a personal explanation, our standing order 42 is not open to debate. However, let me say that this is one major landmark judgment by the Supreme Court that the National Assembly had done that job and the court upheld it. The idea of what method of primaries should be adopted at the moment is entirely left for the political parties to decide. But as we implement the Electoral Act 2022, we are supposed to be very observant of the strength and weaknesses of the law. Essentially, this law is supposed to improve on the electoral processes and procedures in our country. So it's for us to ensure that where there are weaknesses, we try to come up with measures, amendments to deal with issues of weaknesses in the law. And I'm sure it will come full cycle by the time the 2023 general elections are held. I have no doubt in my mind that all of us in the National Assembly, not only in the Senate, but in the House as well, feel that we must do everything and anything possible to make this Electoral Act serve the purpose for which it was passed and assented to. Therefore, I believe that we should work tirelessly to take note of all those areas that we feel are not strong enough or are weak points in the law, with a view to strengthening them before we finally take our exit in 2023. With these remarks, I commend the leader for this personal explanation, but I want to also say that this is one law that saw all the three arms of government involved, one way or the other, in the processing, in the assenting, in the interpretation and judgment. Thank you very much. Distinguished Senator Michael Opemi Bamidele.